This is Derrick Broze. Today we're going to be talking about Lysander Spooner, who was an American anarchist that everyone should know about. I'm going to be discussing a chapter on him from the book Men Against the State, which I highly recommend. The chapter is titled Lysander Spooner, Dissident Among Dissidents. And this is a brief summary of that chapter and mentions his important works, his ideas, his life, and some of the things you should know about him. So check this out. I did another video like this on Josiah Warren. I've also done one on Samuel Konkin. I'll be doing another one on Karl Hess, historical and modern anarchists that I think are important. So please do check those videos out and look for more in this series. So let's start. Lysander Spooner was born on January 19th, 1808 in Massachusetts. He is seen as a unique individualist anarchist because most individualist anarchists' economic thought can be traced back to their relationship and their friendship to Josiah Warren and learning from him, except for Lysander Spooner. So he's seen as unique because of his thoughts were sort of developed independently of the movement. Some of his works were published in well-known journals like Liberty by Benjamin Tucker and others later in his life, but for the most part he developed independently and he contributed some great thoughts. When he was 25, he became a clerk in the office of the Registry of Deeds in Worcester, Massachusetts. Later, he really got into the free thought movement. He wrote a pamphlet called The Deist's Reply to the Alleged Supernatural Evidences of Christianity and was really about rejecting religious authority as much as he would later in his life reject the state and governmental authority. He was a very strong, ardent critic of the Constitution, both for economic and political reasons. He regarded the Constitution primarily as a device which afforded opportunities to minority groups to exploit others through the instruments of special privileges. So he believed that compulsory legal tender and bank charters were against the Constitution and were a big hindrance to freedom and provided opportunities to a minority of the population, which were, the elite banking elite. It gave them privilege through the state that gave them power over the majority. He was also against corporate entities. This is a quote from one of his works. He says, "The idea of a joint incorporeal being made up of several real persons is nothing but a fiction. It has no reality in it. It is a fiction adopted merely to get rid of the consequences of facts. An act of legislation cannot transform 20 living real persons into one joint incorporeal being. After all the legislative juggling that can be devised, the company will still be nothing more, less, or other than the individuals composing the company. The idea of an incorporeal being capable of carrying on banking operations is ridiculous." In 1844, he founded the American Mail Letter Company. He argued that the Constitution did not call for a monopoly, so he called for competition to go ahead and compete with the U.S. Postal Service. And he argued this based on Article 1, Section 8 of the Constitution. And in his arguments, he called suppression of competition, as far as the press goes, a violation of the freedom of the press. Because essentially he was saying, if you're free to make documents and to write whatever you want, but you're not free to distribute them other than the means of the government. Of course, this is before the internet, so the only means you had to distribute information was by mailing it across the country. But the government maintained a monopoly on that, and so his argument was as long as that monopoly exists, that is therefore a violation of the freedom of the press, because what good is it to have the freedom of the press and to write if you don't have the freedom to actually distribute that? He was also an advocate to open banking to all people, and he really believed that that was another form of control that existed, is that the government maintained monopolies on banking institutions and on charters and on legal tender. And in 1846, he wrote Poverty, Its Illegal Causes, and Legal Cure. He was a huge advocate of the idea of natural law. He believed that everyone was entitled to the fruits of their labor. He says, "Nearly all the positive legislation that has ever been passed in this country, either on the part of the general or state governments touching men's right to labor or their rights to the fruit of their labor, has been merely an attempt to substitute arbitrary for natural laws, to abolish men's natural right of labor, property, and contract, and in their place establish monopolies and privileges, to create extremes in both wealth and poverty, to obliterate the eternal laws of justice and rights, and set up the naked will of avarice and power. In short, to rob one portion of mankind of their labor, or the fruits of their labor, and give the plunder to the other portion. He also was an advocate of the idea that monopolies and credit was what was causing inequalities in the United States during his lifetime. In 1861, he proposed the idea of a decentralized bank, which was similar to a bank that had been proposed by William B. Greene and similar to some ideas by the anarchist Proudhon. And he said that sound money could be backed by any durable, tangible wealth using this decentralized banking idea. And he proposed two more banks in 1864 and 1873. And again, he said the Constitution did not delegate a monopoly on currency, nor did it require the people to use the state's currency. And as he evolved, he became more and more of an anti-statist and calling out the government. He was also very critical of slavery. In 1845, he published The Unconstitutionality of Slavery. He said, "A state is simply the boundaries within which any single combination or concentration of will and power are efficient or irresistible for the time being. Natural law, which recognized the validity of contracts, which men have a natural right to make, permitted the foundation of government on this basis, but only if the contract was that of an association of individuals who entered into this agreement consciously and voluntarily by each as an individual." So he said that the government's contract, such as statutes, were not consistent with natural justice for the better protection of men's natural rights. And here's another quote from him. He says, "If the majority, however large, of the people enter into a contract of government called a constitution, by which they agree to aid, abet, or accomplish any kind of injustice, or to destroy or invade the natural rights of any person or persons whatsoever, this contract of government is unlawful and void. It confers no rightful authority upon these appointed to administer it. The only duties which anyone can owe to it or to the government established under cover of its authority are disobedience, resistance, and destruction." So as he evolved and continued to question the nature of government itself and the structure of government, he also started to question the jury system. In 1852, he published his essay on the trial by jury and promoted some of the first ideas of jury nullification. He believed that on the basis of common law criteria, that there had never been a single legal jury trial in the U.S. since the Constitution. And he said, "If the people are as good as their word, they may keep this government within the bounds they have set for it. Otherwise, it will disregard them." He also spoke against the rule of majorities, and he favored minority rights. Following the Civil War, he started to release his series of pamphlets were known as the No Treason series. They were all numbered accordingly, and he talked against war, he talked against the Republican Party, and against democracy. And he also said that government cannot claim to be born out of the consent of the governed unless every individual has agreed to fully support or fund that government. And there's a great quote from him on this topic. He said, "Consent from each individual was required to furnish support to the government either through paying taxes or supplying some type of personal service. Without this, it must be admitted that the government in question is not founded on consent at all. To obtain the consent of only so many as was necessary to obtain control over the remainder was not establishing a government by consent. Rather, it was the fruition of a mere conspiracy of the strong against the weak." And he said that it was the surest sign that a government was not free was the prevalence of coercion in securing support of any number of persons, no matter how small. "There is no other criterion," he said, "by which to determine whether a government is a free one or not than the single one of its depending or not depending solely on the voluntary support." So in a lot of ways, he was the promoter, one of the earliest promoters of the idea of taxation being theft. And he called government a group of men making political agreements binding future generations. And he favored voluntary organization through free association. Also, when it comes to the Civil War, he did not believe that the North was treasonous in their act of engaging against the South. He also believed that if the people were given a choice to sign the Constitution, they would reject it, and that the ability to vote 2 or 4 or 6 years was no remedy for the situation, that people were replaced by others who exercised similar absolute and irresponsible power. He wrote that in No Treason number 6. And again, he was very adamant that taxes were taken by force and that given the choice, people would not choose to support this. And until the government actually had voluntary support, either through funding or some other service, that they couldn't be seen as legitimate. In 1882, he released his book, Natural Law, where he explored the concept even deeper, and he hoped to establish, quote, principles of natural law, a science of justice. And he said if there was no natural principle of justice, the moral standards in justice were meaningless. And he also held coercion to be unjustified under any circumstances. Towards later in his life, he retired to Boston and continued to write. In 1885, he published a letter to Grover Cleveland, who was the president at the time, and he declared that the devotion to public welfare, which was increasing at that time, would inevitably lead to the destruction of individual rights under the guise of prosperity. And he had an extreme contempt for the party system at that time. So even at this point in the late 1880s, as the government was getting stronger in the Reconstruction era, post-Civil War, and the U.S. was rebuilding itself, he was still adamant the state was the problem and that the party system was the problem and that people were not being represented fairly. So these are all very revolutionary ideas for his time, and there were other individualist anarchists at the time, as I said, Josiah Warren before him, and Benjamin Tucker and others that were alive towards the end of his life, but for the most part he existed independently and wrote all of his books and pamphlets on his own. And he died May 1887, leaving behind a legacy of books, pamphlets, including the No Treason series, his work on juries and natural law, leaving lots of material to dive through and to learn, and influencing later anarchists through the republishing of his work in Benjamin Tucker's newsletter, Liberty. So that is my short report on Lysander Spooner, a dissident among dissidents. Definitely I advise looking more into his work. Read the works themselves. I would say read Natural Law, read the No Treason series, look more into the American Mail Letter Company, because it was a really revolutionary idea for him to create a competition with the government instead of trying to work within that system. Also, I would read the Unconstitutionality of Slavery and his essays on trial by jury. Those are all great works. Thank you for listening. Peace.